Hello. I don't even know what I'm doing today. I was looking around going, do I have everything set up? I've had everything set up for quite a while, but huh, well, yeah. Flashman, I'm beyond tired. I think I finally fell asleep around 11:30 last night, and my dogs are like, still don't care. It's 4 o'clock. Get up. Actually, I started waking me up at 3:30, and I was like, no, no. They're like, okay, 20 minutes. So they went outside and started barking, but it's okay. I'm all good. I I kind of felt bad for that picture, Gabby, but it's our final day. We are finishing Eileen like Florida did. Spoiler alert. Uh, sorry. I'm sorry. I may just kind of be just all over the place. All over the place. But I had to change the picture for the last day. I kind of felt bad. Oh, hey, Sir Frank. How you doing? Oh, hello, Adair. How are you today? Yeah, it technically. So I am going to spare you guys one expert. The state put on, or I'm sorry, the defense put on three psychologists. I'm not going to play the last one that they put on. He's an hour and a half. He doesn't say anything different. He just talks about borderline personality disorder, her having it, blah, 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 blah. We heard the whole story from the first two repeatedly. There's nothing new. So I'm going to skip that one. You guys are more than welcome to go to the Court TV website and watch it. But I am going to play the state's rebuttal psychiatrist and make sure that you remember the difference between a psychologist and a psychiatrist. Don't worry, we'll hear about it. And then her I'm I'm sorry, I'm too tired to figure this out. Her brother. Her her brother I don't so okay, her grandparents adopted her. I think he's actually her uncle. There's too many brother cousins in these trials sometimes, but I think he's her cousin, like, technically, but her brother, since she was adopted into the family, don't know. He calls himself brother. I called him brother cousin. Cousin brother. Um, I do not have 6 more minutes. No deal. You were attacked by your 20-pound cat this morning because you started panicking. She decided to take over for you. Well, I hope whatever you were panicking about, the cat helped since the cat was taking over for the service dog. Also, all is good between Zach and Flashman. If you don't know what happened on last night's stream, it was quite entertaining. Uh, Flashman accidentally timed Zach out for 30 minutes. And we could not figure out how to fix it. And it was funny. I was over watching Baker's stream this morning, and Nita Wow came in. She's like, "Did you hear that Zach got timed out in AJ stream last night?" I was like, "It was an accident." So Baker was looking at his chat like, "What is happening? What is going on?" And then Zach all of a sudden he popped in. It's like, "I see no humor in it." I don't know. It was funny. All is well. And he actually told us how to fix it if we ever should do that again. But I think Flashman will probably be a little scared of the buttons from now on. That's just Oh yes. And if you didn't see, Zach's response in Discord to Flashman this morning was very entertaining. It is funny. Oh man, Adair, did you get snow this morning, Adair? I saw on the map. Like there was blue stuff over your state. I'm like, holy crap, don't send it here. Do not send snow here. He can't time me out in Baker's. He's not a mod. And I'll be very careful to go where he is. Yeah, that's what he said. To fix this every time for a lesser time. And I mean, we were trying really hard to fix it. Gabby was sending me stuff and I'm going, I can't find anything that says that. And it was funny. And I will tell you guys, just on a different note, I don't have any yogurt, but I almost put a bunch of sour cream in a bowl to start the stream this morning. Not I wasn't going to eat it. I mean, I could. I like sour cream, but I just thought it would be funny. Yes, there was all the yogurt talk yesterday during Lori Vallow, not in a dirty way. I just have a thing. I have a thing against yogurt. I like yogurt, but so Flash fan, do not say the T word. Do not say the T word. So my plan is to do Aileen Wuornos trial, not to do Aileen. That's gross, and she's gone. I have my stream set up for Lori Vallow's trial, so I just have it set to private right now because I wasn't sure time-wise. And if I get a little buffer in, perfect. And then my plan. Hey, Sharon. Thank you. That's my my serial unaliver intro. Lori Vallow doesn't have one of those. I thought about making it one for her, but I haven't had time. And then I am not sure. I'm not sure what I'm going to do about part 2 for the afternoon session tonight because I was just invited on to another stream for the evening, and I thought I had to go to dinner with my dad and my brother, but I think that's going to be canceled. And I really want to go on that. It's with the expert, so I really want to go over there and have some fun. He's celebrating reaching, I think, 7,000 subs. So I will not. So that's my plan. I'm just not sure what to do with part 2 of Lori Vallow. Because if they start getting into stuff that's going to be interesting, like the text messages and all that stuff, I want to be there. But on the other hand, I told the expert that I probably wouldn't be available till after 8. So if I can cover that and then go over there, perfect. And then Monday, let's see, what day is this? Wednesday. Tomorrow I will do whatever day 4. I'll come. I will do day 4 like I did yesterday. Friday morning. I don't plan to stream Friday morning. But I will stream when Lori's trial starts in the afternoon because I will have my granddaughter, and I think I can if I can do that, do the break, give her a break, and then come back and do the rest of it. I think I can make that work. That's my plan. Yeah, so I think I can do it all, Flash fan. As soon as we get this started, I've got to text Mr. Hanf back and my dad and get everything lined up. It's going to fall into place. It's going to be great. It's going to be awesome. I will boomer all of it or none of it. But I don't know. The day is young or it's over. I'm not sure. Not sure which one yet. I don't know. All right. This is Dr. Barnard. I don't know. They'll say it. Yeah, Terry. I appreciate you being glad that I'm streaming more often. I don't know how long I can keep up the schedule. I am running on fumes. Right, my stomach. Sorry, I ate some chicken salad, so my stomach's going to be like making all kinds of weird noises because it does that after I eat. I'm not hungry. I just ate. Also, I'm going to click something and I don't know what's going to do. And I don't expect it. You guys don't do anything with it because unless you want to. But StreamYard, okay. Here we go. Unless you're going to be a streamer, you won't care about this. But I want it to go away. All right. I fast forwarded through like his credentials and stuff. Oh, it didn't go away. All right. We're going to start. The defense stipulated that they knew him already. And of course, they have to keep asking him questions. The defense did the same thing. And so here we go. Let me know how the sound is. He's 30 minutes. The brother cousin's 30 minutes. And closings are an hour. And then verdict and sentencing is 30 minutes. That's what we got. So here we go.
Could you tell us, please, what your medical specialty is?
The medical specialty is forensic psychiatry. This is a subspecialty of psychiatry, and basically it's the interface of psychiatry and the law.
Your Honor, we tender Dr. Barnard as a forensic psychiatrist. Could you please tell the jury the difference in training between yourself and a psychologist?
The person who is going into psychiatry essentially has had undergraduate training similar to the psychologist, but then it begins to be different with the psychiatrist taking 4 years of medical training, year of internship, and then 3 years of residency, whereas the psychologist, after the undergraduate degree, has taken 3 or 4 years of graduate training in the specialty of psychology. The psychologist works toward a degree of a PhD, and the psychiatrist is an MD. There's a lot of difference in their training during this years of specialization, in that the psychiatrist gets more emphasis, I think, in terms of the biological medical aspects, and the psychologist will get more in terms of doing specialized psychological testing.
Can a psychologist prescribe medicine under current law and state law?
No.
But a psychiatrist such as yourself can and does prescribe medicine?
Yes.
Did you have occasion to examine pursuant to court order Aileen Wuornos, assistant courtroom today?
Yes, I did.
Is this the lady that you examined?
Yes.
You want to make the record?
Flash fan, the T word I don't want to hear. You said it earlier, and I said, don't say that, and then you deleted it. It starts with T, ends with A, and it has a U and an N in the middle. If I spelled it out correctly, I might throw up.
Like identification. Thank you. Sir, could you tell the jury, please, when it was that you conducted the examination and where?
Okay. Basically, I saw Ms. Wuornos in the Division of Forensic Psychiatry in Gainesville on January the 9th of this year. And it took place from a little before 9 until about 5 afternoon.
Was there anything at the outset of the examination that was disruptive or out of the ordinary?
She was somewhat agitated over what had taken place on the trip over, that she was concerned about.
What were her complaints?
She was essentially
objection as to relevancy.
Overall.
She was basically saying that the officers had made some sexual remarks to her, and that she considered it, I think, to be a form of inappropriate remarks.
Was there some threat by her, to your knowledge, to save the officers who tried to rape her or to rape her?
According to the following question, Your Honor.
This was not from her, but from the officer who was with her, said that in the Sally Port, prior to coming over, she had made such a remark.
And was she offered a rape kit at examination to detect if someone had intercourse with her?
Yes.
She declined the rape kit examination.
Yes.
Based upon your examination, if you will, just briefly tell the jury what you did. I'm not going to ask you to go through her history all over again. That's been gone through, I think, 3 times already. So just basically tell the jury how you prepared yourself and how you were able to reach a conclusion if you were.
Essentially, with the defendant, I inquired about her understanding of the legal charges against her, her account of the alleged crime, specifically what happened on that day, and what took place subsequent to that time. I inquired about any prior arrests she may have had, went into her past history, determining about her family of origin, how she got along with different family members, her educational record, employment history, military history, marital history, medical, psychiatric, substance abuse history, did a mental status examination to carry out certain kinds of things to determine if she was oriented, how her memory was functioning, and so forth. In addition to that, I have reviewed extensive materials that have been provided by the Office of the State Attorney and Office of the Defense Attorney.
And were you able to reach a conclusion or opinion based upon reasonable medical probability as to her mental condition as it relates to the legal definition of sanity and her ability to conform to law?
Yes.
Could you tell the jury what that conclusion was?
Basically, it was my opinion that at the time of the crime, she was legally sane, meaning that there was no mental disorder or defect that prevented her from knowing the nature and quality of her acts or the wrongfulness of them.
And would that opinion indicate that she is legally responsible for her acts?
Yes.
If the doctor knows the legal definition.
You can ask those officers.
Yes, Judge.
You had previously had contact with this woman, had you not?
Yes, sir. Had.
And could you tell the jury about that, and what the purpose of that previous contact was, and what the results of the previous contact?
First time I saw her was September the 19th, 1981. At that time, I was appointed by the court to perform a psychiatric evaluation, essentially determined that she was competent to stand trial and that she was legally sane at the time of the alleged crime. In my opinion, she was competent at that time, as well as sane at the time of the alleged crime.
No further questions, Your Honor. Thank you. Thank you, Doctor.
James Wire.
How are you, Dr. Barnard?
Fine.
A psychologist is a qualified mental health professional in your view. Is
Yes.
that correct? In fact, you know Dr. McMahon. Do you have any questions about her qualifications?
No.
Have you worked with her in the past?
I have.
Have you reviewed, have you talked to her about the results of her testing in this case?
Yeah, I did.
Have you relied on the results of testing that she has provided in this case and others
Yes,
in formulating an opinion?
yes,
Psychiatrists are not licensed to provide psychological and neuropsychological testing, is that correct? In general, as a general matter.
as a general rule.
And when a psychiatrist needs the benefit of neuropsychological or psychological testing, they would refer someone to a psychologist,
Again, it's a general rule.
as a general rule.
Yeah.
It's sort of both are mental health practitioners and both come, as you indicated, from a different perspective, but towards the same area, towards mental health.
Right.
You were at, by the way, did you have any questions about Dr. McMahon's diagnosis in this case?
I agreed with her diagnosis, but I had another one also that went with.
Okay, let's talk about the one you agreed with her on. You agreed with Dr. McMahon that Lee Wuornos suffers from a borderline personality disorder, is that correct?
Right.
And in reaching that conclusion, you agreed with Dr. McMahon based on your knowledge of Ms. Wuornos' background, her history, who she is, and what the testing reflected, all of the facts that you had.
Yes.
And you indicated that you received, I guess, a stack of material from both the defense and the prosecution.
Right.
A borderline is an identity, part of what that is an identity disturbance, is that correct?
Yes.
And you saw evidence of that in Ms. Wuornos' case?
Yes.
In Ms. Wuornos' case, did you also see an identity disturbance that is pervasive in her history?
Yes.
You also saw affective instability in her case, did you not?
Right.
What is that? What is affective instability?
Basically, it means they have difficulty controlling their emotions and that they may go from one kind of feeling or affect rapidly to another.
In fact, she is impulsive. You saw that during your review of records and your interaction with her.
Yes.
And did you reach an opinion as to whether she has deficiencies in judgment?
She did.
Did you reach an opinion as to whether she has deficiencies in insight?
She does.
Did you reach an opinion as to whether her history, her familial, developmental, environmental background is consistent with that of people who suffer from borderline personality disorder?
I don't think that you can necessarily say that there's one kind of background, but it's not inconsistent.
Did you perceive evidence in dealing with her of a history of involving suicidal gestures?
Yes.
And in dealing with her, did you observe problems in affect?
Problems in affect, meaning her ability to handle anger too well?
Yeah, control over mood.
Yes.
One of the criteria which the DSM-3R relates to, speaks to when dealing with a borderline personality disorder is a frantic effort to avoid real or imagined abandonment. Is that something that's consistent with people who suffer from that disorder?
It's found in many of them. It's not necessarily always there, but it's a frequent kind of dynamic that's found.
And the opinion that you reached that Ms. Wuornos suffers from a borderline personality disorder was reached to a reasonable degree of psychiatric certainty, was it not?
Yes.
You didn't simply say, well, Betty McMahon said it, so I agree. That is your independent opinion.
Yes.
In addition, did you consider the testing provided by Dr. McMahon, and I think it was Dr. Bervini, as to organicity and the issue of cerebral or cortical impairment in Ms. Wuornos' case? Did you, during your evaluation, find any reason to disagree with that?
No.
And she did show some impairments.
Some mild, minimal impairment, yes.
Some mild what?
Or minimal impairment.
You spoke a little bit on direct examination of Ms. Wuornos' military history, the area of military history. Did she make it to the military?
No.
Why not?
She said she failed some of the tests.
The prior case that Mr. Tanner spoke to you about, the prior robbery involving Ms. Wuornos, you prepared a report in that case.
Yes.
And in that report, you included certain you included a discussion regarding your evaluation.
Yes.
You said in your report, she and her boyfriend had had an argument the day before the alleged crime, and on the day of the alleged crime, she woke up and still felt angry at him and felt he might be like other guys and would take advantage of her. Is that consistent with what you said? Is that what you said in the report?
Basically, yes.
You also said that she bought a six-pack of beer. She rode around thinking that she might shoot herself. Is that one of the suicide attempts that we were talking about, or suicidal thoughts that we were speaking about?
That was not one of the actual attempts. She had some suicidal thoughts in it, but she did not make an overt behavioral attempt.
Okay, there was another time that you're aware of where she made an actual attempt.
Yes.
And that's when she shot herself in the stomach. In addition, in the report, you indicated she continued, but then she had thought of what she would do if she continued to drink and ride around. She had thoughts of calling her boyfriend, but then had the thought of what he would do if she robbed a store. She thought if he got her out, it would prove that he loved her, whereas if he did not, it would prove that he did not love her and she would kill herself then. She said she did not think of a prison term because she was too drunk at the time, and all she cared about was finding out if her boyfriend loved her. You prepared this report in 1981,
Right.
which is not at the time of the prior evaluation. And this was the report regarding your opinions as to the other offense. So
Right.
not a recent report regarding that offense.
Right.
You indicated in the report, you also had a section as to her history. And the section as to her history that you included in that report was back then, before anybody heard of Mr. Mallory. Is that correct?
Yes.
You wrote all this in 81. And in 81, you indicated that she got along with her adopted mother, but did not like her adopted father, who she thought as being cruel, and sometimes when he was drunk, he hit her with a belt. Do you recall that?
Yes.
That was back in 1981.
Right.
Ms. Wuornos told you these same things in the current evaluation.
Right.
What she told you about her family history is consistent now as it was when you saw her in 1981. As to her views of her mother and father and grandmother and grandfather, I guess.
Basically, right. Mhm.
You also indicated in the report, you made reference to her shooting herself in the abdomen and being put in the Halifax hospital. She said she had been raped and beaten up to 10 or 12 times as she hitchhiked about the country and was unconscious once for about 10 minutes after she fell while drunk. And that was also in 1981, before anybody heard of Mr. Mallory.
Right.
She has made 6 suicide attempts between ages, I can't read the first one, can you?
14 and 22.
14 and 22, but then went on to say that all of these were not attempts to take her life. She began the use of alcohol at age 12 and used it on a regular basis by age 17. You also indicated that in 1981.
Yes.
You also indicated in that report that she had deficits in recent and remote memory in the 1981 report,
Mild deficits.
mild deficits. In the 1981 report, you did not provide a diagnosis. You did not write one out.
Right.
Is there anything that you saw when evaluating Ms. Wuornos in 1981, if you could sort of just go back in time with me, which would be inconsistent with a diagnosis of a borderline personality disorder?
No.
Okay, so she had it in 1981 when you saw her.
If I'm saying she had it now, she had it in 1981.
Okay. You talked in your report about it. Well, Mr. Tanner asked you questions about the question of sanity. The borderline personality disorder and the other impairments that Ms. Wuornos has, those things were with her when she was with Mr. Mallory, were they not?
Right.
You also talked a little bit with Mr. Tanner about the question of competency. Does the question of competency relate to what happened at the time of the offense? Can somebody, in other words, be competent, nevertheless suffer from some impairment at the time of the offense?
Definitely, you can. It's, you do not have to have incompetency because someone has a mental disease or defect.
Okay, competency has to do with whether somebody can stand trial with an attorney there with them and so on and so on.
Yes.
Doctor, just one or two other questions. Aileen Wuornos told you that she was drunk or drinking when she committed that robbery back in '81. In fact,
Yes.
and
It was a mixture of alcohol and equilibrium, I believe she said.
pills and
Yes.
and alcohol. Were you aware of the pre-sentence investigation report that the victim said she didn't appear to be intoxicated at all?
No.
With regard to the other diagnosis, you said that she does have borderline personality disorder.
Yes.
What is the other diagnosis? The competency.
The other diagnosis is an antisocial personality disorder.
And Aileen Wuornos is suffering from an antisocial personality disorder, correct?
Yes.
In layman's terms, what does that mean?
Basically, what it says is that these people have difficulty with moral values. They have trouble controlling their impulses and oftentimes do things that are against society, against the moral values, at times breaking the law. That they lack the degree of conscience that many people have who do not have this disorder.
With regard to Aileen Wuornos and the crime of committing Richard Mallory, in your medical opinion, was it committed while she was under the influence of an extreme mental or emotional disturbance?
No.
And with regard to the killing of Richard Mallory by Aileen Wuornos, did she have the capacity to appreciate the criminality of her conduct?
She did.
And did she have the capacity to conform her conduct to the requirements of the law?
She did.
And her personality, borderline personality disorder, and antisocial personality disorder did not impair her to take away those abilities, did it?
Not to an extreme or a significant degree.
Okay. No further questions, John. Thank you.
Doctor, just to clarify, in your report, you indicated that Aileen Wuornos did have an emotional and/or mental disturbance at the time of the offense.
She did.
And in your report, you indicated that Aileen Wuornos did have an impaired capacity to conform her conduct to the requirements of the law at the time of the offense.
Yes, she did.
And in your report, you did indicate that Aileen Wuornos at the time of the offense had an impaired capacity to appreciate the criminality of her conduct.
No, not that one.
Not that one?
No.
Okay, the other two you did.
Other two I did, and what I did here was to basically say that he did not reach this to the statutory degree, but I took out the adjective so that it could be considered for non-statutory mitigating circumstances.
Okay, so you're saying that she had an impairment to conform her conduct to the requirements of law, but not a substantial impairment.
That's right.
So it's a non-statutory mitigating circumstance.
Yes.
You're saying that she had an emotional or mental disturbance, but not an extreme one.
Right.
So that too is a non-statutory mitigating circumstance.
Right.
In your view, those disturbances and impairments were with her at the time of the offense,
They were
and they mitigated in this case,
non-statutory.
non-statutorily.
We deserve it, Zach. Hey, now you crossed the line. We deserve it. I tried my hardest. I couldn't figure it out. We couldn't. Oh my! That's why you don't play games with. You don't play the timeout game. Someone ends up getting hurt. Oh, we love you too, Zach. It was not the same. You missed such good conversation when you could not chime in. It was like, it was just not, it was horrible. It's horrible.
Is there an interplay between a borderline personality disorder and an antisocial personality disorder? Can
Personality disorders, I think, in general, have a lot of overlaps, but you're not going to find some that are pure, and you're going to find some overlap between different ones. And specifically in these two, there's overlap between.
If you have a person with a borderline personality disorder and all the tension, the anxiety, the inability to cope that comes with that disorder, is that something that could affect a person in such a way that they commit antisocial acts?
Adair, you made 250,000. Oh my goodness. I like this doctor. He's almost done because he just answers. He's not like the other doctors that had to give these big, long, drawn out explanations of everything. They're like, is she this? Yes. Is she this? No. Would this affect her this way? Yes or no. He's just straight to the point. Here's the answer. I'm not going to give you a book on why. Exactly. 8 hours later. About the length of time Zach was timed out. Sorry. Still fresh.
So that they would meet the criteria for an antisocial personality disorder?
You could, but I think that if you look at the longitudinal history of the defendant, what you see is that her behavioral problems in an antisocial way began, during her teenage years and have continued across the time.
And so did her borderline personality
Yes.
disorder. That also something that was
Right.
with her in childhood.
Right.
Under the DSM-3 criteria, the following description is given as to antisocial personality disorder. Frequently, there are signs of personal distress, including complaints of tension, inability to tolerate boredom, depression, and the conviction, often correct, that others are hostile toward them. Is that something that's consistent with people with an antisocial personality disorder?
Not necessarily, but it is not inconsistent with.
And that's one of the criteria provided as to things to look for in those individuals.
Yes.
As to either of these disorders, a borderline personality disorder or an antisocial personality disorder, it is not something that someone chooses as a child, is it?
No.
So that someone doesn't wake up one morning and say, I want to have this disorder when I grow up.
I don't think that they choose to have the disorder. What they may choose is some of the decisions about what I should do behaviorally, and that this behavior then can escalate or get sufficient kind of reinforcement so that it becomes more and more ingrained so that they don't have to do as much choosing, and that it becomes easier for them to carry out some of the antisocial behaviors.
That's a person who is borderline and has problems may drink, for example, to deal with those problems. That reinforces the behavior, that kind of thing.
Yes.
In terms of either disorder or both, they're both listed in the DSM-3R.
Right.
And this book is a book that pertains to disturbances and disorders.
Right.
There's no category in here, normal.
There's a category of no mental illness.
Okay, there's a category of no mental illness, but the rest of the specific disorders listed are all people who are disturbed.
Right.
Thank you, Doctor.
Ms. Barr. Just ask clarity, Doctor. Aileen Wuornos did not meet either of the statutory mitigators in regard to mental health, did she?
Asked and answered. Objection, Your Honor.
Overruled.
She didn't meet either one of those two, did she?
No.
The only one that your testimony,
Objection to that construction, Your Honor.
Let me finish the question.
no further questions.
Any further?
Oh my God.
She had a mental or emotional disturbance
Yeah.
at the time of the offense.
Asked and answered.
Yes.
She had an impaired capacity to conform her conduct to the requirements of the law at the time of the offense. She had the cerebral dysfunction that's reflected by the neuropsychological testing at the time of the offense.
Yes.
She had the borderline personality disorder at the time of the offense. She had her history that, and whatever one carries with them based on a dysfunctional family at the time of the offense.
Yes.
She had her history of alcohol abuse at the time of the offense.
Yes.
She had her inability to cope that she's reflected throughout her life at the time of the offense.
Yes.
She had her lack of judgment at the time of the offense.
Yes.
She had her lack of insight at the time of the offense.
Yes.
She had her emotional lability, her emotional problems at the time of the offense.
Yes.
And she had her impulsiveness at the time of the offense. And she had the various deficits she suffers from that are either genetic and or environmental in nature at the time of the offense.
She did.
And you have testified previously as an expert in criminal proceedings in capital cases.
Yes.
All of these things are non-statutory mitigating factors, is that correct?
Yes.
All 12?
My understanding that the jury can consider the statutory as well as non-statutory circumstances.
And in your view, from a mental health perspective, all of those things mitigate in the sense that they describe the mental state of the person at the time of the offense.
Now, I would object, Your Honor. The doctor doesn't decide what mitigates, the jury decides.
You withdraw the question.
What's your other question? Thank you, Dr. Fillon.
And Dr. Bernard, she had the intent to shoot Richard Mowry to death when she shot him, didn't she?
She did.
No further questions.
Well, all right. Hang on. It just goes to the next one. It's so friendly, but it's all muted. And we have closed captions again, spoiling us today. The problem, I liked I understood that, well, I'm not saying I liked. I understood what the defense was trying to do there at the end. The problem is they're talking like she had this from age whatever, young to now, and she didn't do anything all that time, and then all of a sudden she did. I don't know why. We'll never know why. She probably would never give us an honest answer of why. And she's the only, well, she was at the time the only one that could tell us what happened. All right, this is cousin turned brother, Barry.
Please introduce yourself to the ladies and gentlemen of the jury.
Okay, I'm Barry Wuornos. I'm Aileen Wuornos, his brother.
So you were raised by your father and mother, Ms. Wuornos' grandmother and grandfather in the same home, were you not?
That's true, but actually, biologically, they're grandfather and grandmother, but legally, we adopted Aileen.
Could you describe your family's lifestyle, the interaction between your parents and yourself and your other siblings, including Ms. Wuornos, when they were first adopted and brought into the home until you left for the service?
Well, I would say it was a normal lifestyle. We were pretty straight and narrow family. Very little trouble in the family. While Aileen was growing up, very little trouble from the day we picked her up at, I would say she was around 2 years old, to about 10 or 11 when I left for the service. And that's about all I can say. It was just a normal upbringing for all of us.
Can you tell us some things about your father, what kind of a man was he?
Well, he was kind of a disciplinarian when it came. Are you speaking to discipline or upbringing?
Well, what was your impression of your father being
Oh, he's
brought up as a child?
Well, he was a man of very strong character. Gentleman, he was laid down strong rules, but a man you could really look up to.
Was he the kind of man that would beat a child?
Oh, absolutely not.
In all the time that you lived in that house with Aileen Wuornos, did you ever see him beat her?
No,
Leading
no.
protection.
Well, tell us what you observed between the interaction
Well, when
between
you
your
said-
father.
Yes.
Yes. Yes. Tell us, if you will, sir, in your own words, the interaction you saw between your father and Miss Wuornos from the time she came into your home until you left for the service. And take your time, sir.
The interaction between my dad and Aileen,
What kind of relationship did they have?
a very good relationship until she reached about the age of 9, 10, and 11. About the time I went into the service, things began to get a little tight with Aileen, discipline-wise. She began, the tip of the iceberg there is when she got caught for shoplifting. She liked to toy with fire a little bit and got badly burnt once, but the only disciplines that were ever put down were grounding. And no spankings that I ever saw Aileen ever got, although in my day, I got a few myself, but none for Aileen that I ever saw.
Would you describe your grandfather as being an abusive person? Excuse me, her grandfather, your father.
No, not at all. Like I say, I received normal spankings, but the general rule was grounding. You're in for 2 days or 3 days. That was it.
After you left the service, did you stay in touch and contact with Ms. Wuornos?
I stayed in contact with my mom and dad and received, various bits and pieces of news about Aileen.
Did your father and your mother provide her with a home, shelter, and food and clothing?
Oh, yes.
This incident with the fire, did that require any type of medical care?
Oh, yes. Yeah.
Was medical care denied to Ms. Wuornos?
No, not at all.
You know how your sister got to the hospital?
No, I don't remember, although I know she did go to the doctor, and for a period of many months, she received salves and a gradual clearing of the incident.
Was your father one of the people that helped to apply those salves and dressings to her and take care of her?
Mom, basically. Mom did that, yeah.
Will you describe your mother for us?
Well, Mom was a very quiet, studious, kind of laid-back woman that very in the background sort of woman. Very much easier going than my father, and no punishment of any kind ever came from her sector.
Did your father work or have a job?
Oh, yes, yeah.
What did he do for a living?
He worked for Ford for a long time as an engineer, Chrysler as an engineer, and he got laid off from Chrysler. And for a short time, he worked as a janitor in a school and then went on to be a quality control inspector in Beaver Precision in Troy.
Did your dad have difficulty in going to jobs on a regular basis?
No, he's like me. He just doesn't miss any work. He didn't miss any work at all. We were very punctual and in our upbringing. That's one thing he never allowed, is to slackered as far as going to work or school.
Wanted all the children to go to school?
Oh, absolutely. Yeah, he was strong on school. In fact, I was quite disappointed. I started college at Open University and dropped out to go to the service, and he was a little disappointed in that. He wanted me to see that through, but he was big on education.
While you were growing up, your mom and dad and Aileen, was there another sibling also in the house? That Keith?
Keith, yes, Eileen's brother.
Was Keith or Aileen Wuornos treated differently from you and your own sister?
Not that I ever saw, no.
How about disciplinary was?
No. Well, I can only relate this incident. Now, I said I received a few spankings in my day, and there were times when Dad would discipline Aileen, and once I remember he was going to spank her, she brought up the fact that she was adopted. She said, "Don't lay any hands on me. You're not even my real dad." From that moment on, I never saw any attempt on part of my dad to physically even spank Aileen. But there were groundings, but that was normal in our family.
Do you know when she first learned that she'd been adopted by your mother and father?
I can't give you a date on that. The only thing I can say is she brought that up during that time, and she was 10 or 11 at the time. How long before she knew that, I can't really say.
Were you ever contacted by a Dr. Mann, a Dr. Toomer, or a doctor, excuse me, I'm trying to think, Dr. Mann, Dr. Toomer, and I'm losing Dr. Croft, excuse me. Any of those people ever contact you or try to speak with you?
None of those names ring a bell to me.
No one ever made any attempts to speak to you as far as those three individuals to learn anything about your family, yourself, your father, your mother, or your background?
No. Are they psychologists or something, or what?
You don't even really know who they are because they never
No.
tried to reach you.
No idea, no.
Thank you, sir. Nothing
Okay.
further.
Motion to inquire.
How are you, Mr. Wuornos?
Fine.
Don, stand up for us. Never, okay. Do you recall receiving a call from Don Sanchez, an investigator in this case? You may never have seen him.
No.
You recall receiving a call from him and asking to talk to you about Lee's case?
Sanchez?
Yeah.
No, not at all, no.
Who have you spoken to regarding the Lee's case?
Well, various reporters naturally have called our house. And I've been in contact with Sergeant Leonard Goretzky, the Michigan contact. Basically, that's, and there was a movie producing lady that Jackie, somebody, I think Jack was.
Jerome?
Yeah, there you go. We've turned all these people away from our door because we don't want to have any comment to do on it. The biggest contact I've had was with Mr. Goretzky.
Okay. You talked to Sergeant Goretzky?
Oh, yes.
And you told him all sorts of things?
Right. We made a tape interview about Eileen's background along with me and everything else.
Did Sergeant Goretzky tell you why they needed that information?
Well, she had just been picked up for, at that point, I don't think she had been tried with any of the murders involved. I think they told me that she had been involved in some car burglary or something like that. That's, at that night, that's as far as he went.
And you remember talking
He does look like her. I said it was her cousin brother, but his parents were her grandparents. So wouldn't that make him her uncle brother? Because they adopted her. So then he calls himself her brother because they adopted her. But at first, they would make uncle brother. I said cousin brother. I think it's uncle brother. Hey, Bri. How you doing? I was just kind of wondering how your night went last night. They do not have it. No. No. I don't know because I said cousin brother because we had sister cousin in one case. I don't know. Everything is weird. I was watching I think it was Snapped, like Unaliver couples or something like that. This poor woman, she starts dating this guy that she meets at a bar. Then she meets her biological mother, and when she's meeting her biological mother, she meets her biological brother. Guess who it is? Her boyfriend that works at the bar. And guess what they didn't do? Stop seeing each other. Like, you, okay. I was like, what? Yes. Sister, cousin, brother, father, lover. Anywho. If only it was a joke. There was no joke. Wish. Ah.
to a guy named Paget, an investigator from Citrus County, Florida. It was
Yeah, I believe Paget,
Tony
Leonard
Taddy.
Gretzky, and Taddy were the one who conducted the interviews with me.
any of these guys, Taddy, the prosecutor, Paget, the investigator from Florida, or Gretzky, the investigator from Michigan, you said they told you that Lee had been picked up on something?
Yeah,
Did they arrest you?
no,
Did you write anything like that?
no, absolutely not.
You sat down with them for a while, they turned the tape recorder on, you talked to them about Lee.
Mhm.
Did you ever ask them to let you talk to Lee?
No.
Why not?
Well, there was no reason for me to talk to her.
How about that she's your sister?
Well, no, it never occurred to me. No.
Did you ever?
Because she had been in various troubled times, and I figured here's another time she's in trouble, and I just cooperated. Simple as that.
Did you ask, say, Tony Taddy, how Lee was doing?
I think I asked him if she was incarcerated at the time or in jail, but beyond that, no.
Did you ask Gretzky how she was doing, or Paget?
No, I don't believe so.
Did you ever ask any of the three of them to let you talk to Lee's lawyers?
Outside,
I
go, Your Honor.
Go ahead. The rule over there is objection.
I'm sorry?
Oh, should I answer that?
Yes.
Okay, well, I didn't even know she had any lawyers at that point. I mean, there was no mention of that.
You don't receive, you say you don't remember a few weeks back or a few months back getting a call from one of the investigators working for us.
Objection asked and answered.
Just say,
Lee's mother was your sister?
Yes. Oh, Diane?
Yeah,
Yes.
Diane. What was she like?
You mean now or?
Then, when Lee was born?
Oh,
What was she
when,
like?
oh, she, just like a normal older sister. She had run-ins with her first husband, naturally. And it's what led to the abandonment of Aileen, and we picked her up at age of 2. And she was in trouble at that point, but before that, she was a model student at Troy. But when she got mixed up with Leo Pittman, her life took a turn for the worse.
She was not in the household with you, Lori, and Lee and Keith.
No.
Where was she?
She was with Leo and in various stages of separation or with him, or it was an on and off marriage, and Leo was, well, you know probably as much as I do about it, yeah.
When she was separated from Leo, where was she?
Where was she? I have no idea. I don't know.
Do you remember Lori asking where she was?
At that time,
Yeah.
Lori was just a little girl at that time.
Okay, you're about 9 years older than me, right?
Then
Then
Aileen?
Yeah.
I'm about 12 years older.
about 12 years older than she is? What about Eileen's father? What was he like? Leo.
Leo?
Yeah.
I know very little of Leo. I remember a few incidents as he was trying to date Diane, and he was quite a rousy individual, and he used to tear up and down the street and hang around with quite the hoods in the neighborhood. And he was pretty abusive. One day he threw me down and threatened to choke me if I wouldn't give a message to Diane, and he was generally a criminal type, you know.
Do you know how he died?
Yes, I do.
How did he die?
I heard he was sent to prison and later hung himself.
How old was Diane when she left the home?
I think this is a quick guess, but I think she was 15 or 16 when she got married. I think, or yeah, somewhere around there.
And then how old was she when Keith and Eileen were sent back to your parents?
Well, that would have been 2 years later.
But Diane did not come back, right? Once she left the home, she never
No.
came back.
No.
Did you yourself have contact with Diane?
over the years.
Yeah, well, between the time she left the home and the time she sent Lee and Keith to her grant.
Oh, no.
No contact with her at all?
Oh, well, the time she got married and the abandonment between that time, oh yeah, I saw her on and off, yeah. I'm sorry, I misunderstood you.
Did you find out why she didn't keep Keith and Aileen?
Well, I'm vague on that because it wasn't discussed much in our family. It was a very sore spot. All I know is it was a troubled marriage, and why she left or how she left, under what condition exactly, I can't speak to that point. All I know is we went one day to pick them up. There they were in the apartment, Aileen and Keith, and we took them back home.
The fire that you spoke about a little while ago where Lee was burned, you weren't at home when the fire happened, right?
I had to be at home, yeah, because I remember her face being badly burned. That was just before I went into service.
Were you at the fire itself?
No.
You don't know how it started or anything?
Only from hearsay from Lori. That's it.
Lori was at the fire.
Yeah. Mhm.
You also testified that your dad, Lee's grandfather, was a disciplinarian,
Sure. Yeah.
that the home had strict rules.
Well, no more strict than anyone else, but we did have rules, yes.
Do you remember an incident involving a cat that your father drowned?
I'm not sure, don't.
You had left the home at that point.
Objection, Your Honor.
Withdrawn. How old were you when you joined the military, sir?
I think I was 22, pretty sure.
You testified that, well, withdrawn. Did Lee do well in school?
Yeah, I think she always did well in school until she reached, well, I would say it'd have to be around the 9th grade, and she had great artistic ability. And during her formative years at elementary, and that she was a very good student.
Was she getting good grades?
As far as I know, I never experienced anything bad about her report card, what I can remember.
Were the school people indicating that she needed counseling, as far as you know?
Not while I was at home. No.
Did you ever hear your mother and father discuss any problems that Lee was having in school?
I believe I heard something just before I went into service on truancy. There was a few questions on truancy.
Do you ever remember them discussing whether Lee needed a hearing aid and whether the school people were saying anything about that?
No, never heard anything about that.
Was that a concern for anyone in the family as far as you recall?
It's never been brought up as far as I know. Yeah.
Do you recall them ever discussing Lee needing to be seated in the front of the classroom or needing glasses? Was that a concern for anyone in the family?
No.
And do you ever remember anyone in the family discussing whether Lee had been given medication in school, tranquilizers and things like that? Anybody in the family discuss or was concerned about that? Do you remember anybody in the family discussing whether Lee was having trouble understanding things in school and whether the people at school were saying anything about that?
No, if anything came of that, it was after I,
Excuse me. Objection, Your Honor, as to time frame. This is after this man had left the home.
May prejudice status.
He had already left the home at that time.
When did you leave the home, sir?
like I said, I was 22 and I joined the service in January of '67.
Showing everything today, Gabby. If you don't want it shown, don't put it up there. Yes, Adair, I agree with you. There's something off because I'm sitting here trying to figure out. Whoopsies. Yes, I do know that flash fan. Who's telling the truth? I say that either he just doesn't know because he was out of the house, or she just made up some stuff in her mind that was true to her. I don't know. Or it's somewhere in the middle, you know. if grandpa dad drowned a cat, well, then that's going to just be points against him in my book. So don't hurt animals. You don't care that. Feel a little spicy today, Gabby. Be careful. I'm just kidding. I'm just tired, I think. I don't know. I don't know. I'm here. I'm having a good time. All is well. Except I can't figure what's happening out here. The school records either show what he is asking, and that would not surprise me if he did not know. I don't know. I guess it doesn't matter because we're not there to decide.
And the council could establish that would make Eileen 12 years old.
Actually, I don't think it was that.
11, thank you. I defer.
January 67 is 10, actually.
January 67.
Yes.
We should be 11 months later.
You don't recall anyone in the family discussing any problems that he was having in school?
No, I thought she was doing quite well while I was at home. Yeah.
Now, in January of 1967, do you remember anybody in the family discussing problems that he was having in general? Up until January 67.
Oh, no. Oh, well, let me take that back. There was that shoplifting deal with my mom at Kmart and the fire, the only things that I had heard before I went into service. And then I heard they were while I was in the service, through letters and that, I heard she was getting into trouble.
Okay,
Other trouble.
let's not talk about
Oh,
what you were
before that, those are the only two incidents I can remember.
Well, before you went to the service, you knew about the fire.
Right.
The shoplifting thing you're talking about, was
Right.
Keith Whitley for that one?
Was Keith Whitley? I don't know. I don't remember. All I remember is Eileen was chastised for that.
Do
Yeah.
you remember if Lori was with her?
I don't think so.
Do you know whether Lori was with her?
No, I don't.
I'm sorry, I didn't hear the
Do you
question.
know whether Lori was with her?
No, I can't confirm that. No.
And when you left, she was 10 years old.
10 or 11, I would say. Yeah.
And by the age of 10 or 11, when you left, those are the only two things you've heard discussed that would at all fall into the category of problem.
Exactly. Yeah.
When was the last withdrawal? When you returned from the service, do you remember Lee trying to visit your family or visit your home?
I'm sorry?
On a couple of occasions.
Not that I can remember. I know she drifted in and out. You know, her and Keith were, on the streets quite a bit, and that's about as much as I remember her coming back.
And you and Lori were not Diane's children, you were her brother and sister.
Exactly. Yeah. You don't have any water here, do you? Glass of water, please.
Eileen she's staring that dude down. I hope I'm getting visited. Come here. Bri wanted to see you last time and you weren't in here. She's short, Bri, but there's the German Shepherd. There's the German Shepherd. And there goes the German Shepherd. All right, I tried. Yeah, she just looks very angry or hurt or both. Flashman, I'm gonna have to say you brought up yogurt when I told you couldn't have ice cream after you timed out our best friend Zach for the rest of the night. We're just gonna keep embellishing that story till it's like a week that you timed him out. Just so you know.
What did your mom die of?
I think it was a liver disorder.
Okay, what-
She was anemic and, excuse me. She was anemic and had trouble retaining iron in her system, and it affected her liver very bad. And I think that was one of the causes, even on a death certificate, deficient anemia and liver disorder.
Okay, was it sclerosis of the liver?
No.
What did your father die of?
My dad died, death certificates is accidental carbon monoxide poisoning.
How did that happen?
I came home one day and I parked in the garage, went downstairs to see him. He lived with us in Troy, and he wasn't there. And immediately I was kind of scared, because if he wasn't upstairs where I saw with my wife downstairs, I went back in the garage and he was dead behind the wheel of the car. And I didn't even see him when I pulled my car right next to him.
Did your dad drink?
Yes, he did.
Did he drink often?
I would say he had probably one bottle of wine a day. Never more, and hardly, well, I won't say less, because he had periods where 2 or 3 times in my lifetime where he tried to dry out completely, and he did for like a year at a time. But he would complain, he had bad pains in his legs from the war. He had some war wounds, and he always claimed that the wine was the only thing that could ease that pain. So, but it never affected his work record or anything.
You do not currently reside in the state of Florida, correct?
No.
How did you get here before today?
I was flown in,
Who flew you in?
these gentlemen here.
Did you ever ask these gentlemen here to let you speak to Lee?
No.
Irrelevant, Your Honor.
Is there objection?
Objection, Your Honor.
Did you ever ask these gentlemen to let you speak to Lee's attorneys?
Objection, Your Honor. Counsel could have spoken to this witness. He's had his name since February of last year. He chose to do so.
Well, for this shall I speak, Your Honor, it's not even what I was asking about.
Please check, Mr. Snee.
Thank you.
For that question you have.
I'm sorry.
Answer the question you have.
Thank you, Ms. Warren.
Any further?
No, sir. Thank you, Mr. Moore.
Your Honor, thank you.
Well then, I know. I was like, only one bottle of wine. I guess a bottle of wine a day is a lot, but yes, Bri, like you say, I only had 1 glass of beer, but I filled it 36 times. That just doesn't seem like a lot. Like, when you consider somebody being an alcoholic, it's not what I would have in mind, but they didn't ask me. And we're still waiting for Flashman to tell us how he eats yogurt. Says he doesn't eat it like that, which I don't know what that means. Yes, the war of the podium will be over today, at least in this trial. All right, we are going to go to closing arguments. There's like 15 minutes of them arguing about jury instructions. I'm not playing that. Although the little judge is sitting at the table and he's just got his little judge clothes on. He's cute. That means you don't eat it a lot. Okay. We didn't know. That's why Gabby and I both asked. We thought you had something against yogurt. Gabby and I can't be the only people. And oh, hey, we've got closed captions for the closings too. Wow. We gotta go buy some lottery tickets or something. Y'all need some sleep. That is true. Alrighty, closings and then verdict. And I might want to share my screen with you. See, I told you I'd boom or something. There you go. Sorry. Hopefully that's the worst thing I do today. It'll be a banner day. Here we go again. Take 2. Oh my gosh. He only had to be in court this long for me. This was really, I don't think it was a very long trial in real life, in real time.
We said earlier, I think we all join in this appreciation for your service. No one volunteered. Any one of you could have escaped. In fact, this responsibility avoided it. You chose to meet your responsibility. We all thank you. It's always a little uncomfortable deciding where to stand in this courtroom. By design, you don't stand in the Senate because you hear yourself. So if you were too close, forget us. We want to talk to you. This is the only opportunity I will have. I will be followed by Ms. Jenkins. And then the judge's instructions. I'd like to just briefly talk about the instructions for a few moments and the potential forms of the verdict to help familiarize you with it, although no instruction on the law will come from me or any other lawyer in the courtroom. They come from the court, Judge Blunt only. The form for the verdict is relatively simple. There are 2 potential. One reads, as to count 1, a majority of the jury by a vote of blank, and that must be at least 7, advise and recommend to the court that it impose the death penalty on Aileen Wuornos, also known as Susan Lynn Verhoeven, also known as Lori Christine Grody, also known as Annie Marsh Green, and the date. The other potential verdict, as to count 1, the jury advises and recommends the court that impose a sentence of life imprisonment on Aileen Wuornos, also known as Susan Lynn Verhoeven, also known as Lori Christine Grody, also known as Annie Marsh Green, without possibility of parole for 25 years. To be signed by your foreperson. Neither verdict need be unanimous. If you do not vote by at least a vote of 7 to 5, then you use the second form. If you do vote by majority, which would be 7 to 12, recommend the death penalty, and that should be good. This is known as an advisory sentence, but carries great weight with the court, and should certainly not be taken lightly in any fashion or respect. I know you won't. But only the judge imposes the sentence. Juries do not. Not every murder case, in fact, not even every first-degree murder case is a death penalty case. And your participation as jurors is only a part of a long chain of events that began long before you ever imagined that you'd be sitting here, long after you've departed and gone back to your normal lives. It begins with a decision by the prosecutor to take the case to the grand jury, followed by a grand jury indictment, which is not evidence of anything, it's simply a charge. And then ultimately it goes to a trial where a jury must find unanimously guilt of a capital offense, which you have done. Then it returns to the prosecutor for a decision whether to continue to seek the death penalty. Again, that responsibility rests on the state. And ultimately to you again for a recommendation verdict, and then on to the judge and on into the judicial system. Your responsibilities are here and now. It began in Volusia County, and this makes it in Volusia County. Justice in this case. All
right, I don't know what's going on with StreamYard. So if it's buffering out for you guys, I apologize. It keeps going off in here. It's driving me nuts. I don't know what's going on. Also, Flashman, you said he was a prosecutor. Did it fit then? Did he change it since when Johnny Cochran was a prosecutor? The glove must fit. Even if it doesn't, he's guilty.
mitigate or aggravate based upon what some other jury, judge, or court may do if there is ever another jury, judge, or court regarding this woman. Finality for Mr. Mallory's death, part of the recommendation of this jury. His Honor will instruct you on the aggravating and mitigating circumstances, so you need not try to grope, so to speak, for what should we do, how should we be guided. You will be well guided by the court. You will be told of the aggravating and mitigating circumstances available under law, and there are many more than you will hear about, such as the killing of a government official in the capacity of his duties, and on and on. And there are plenty on both sides. The only ones you need to be concerned with are those which the judge will instruct you. The state has established and offered proof and evidence throughout the trial, and please remember, that includes all of the evidence you've heard since we've begun, of the 11 possible aggravating factors. We have established beyond a reasonable doubt 6. Any one alone, if in your opinion is sufficient to justify recommendation of death, is sufficient. It's not a numbers game, it is a weighing game as to the weight of the aggravator, not how many aggravators versus how many mitigators, but the weight of each and every aggravator proved and or balanced against the weight of mitigators established. We have proven that in fact, and this is one of the aggravators, that this defendant, Ms. Wuornos, has been convicted of a prior violent felony, armed robbery. That is a statutory aggravator. We have proven, and your verdict is verified, that the murder was committed during a robbery, in this case. The third aggravator we've proven is that the murder was committed to avoid arrest. The fourth aggravator we've proven is that the murder was committed for financial gain in the process, in this case for robbery. Your verdict is confirmed that already unanimously. We believe the evidence establishes that the murder was especially heinous and cruel, showing the total indifference of life, and that the murder was committed in a cold and calculated, premeditated fashion. Premeditation certainly was established by your verdict. The mitigators that you will probably hear about, since this is my only opportunity, I want to address them briefly. One, we believe that they will take the position that Ms. Wuornos was under the influence of extreme mental or emotional disturbance. Number two, that her capacity to know what she was doing and to conform her conduct to the law was substantially impaired because of the mental condition. Those two aggravators are built entirely and exclusively upon her stories. If in fact she sat in the car and got out and killed him with deliberation and not as a result of being attacked and ravaged, which she had already objected, then the extreme mental or emotional disturbance, which all the psychologists indicate would have been triggered by this attack, if it were true, is not there. The same with regard to her capacity to understand what she was doing. They will also argue that because of her age, she should not be held fully responsible. At what age do our citizens become responsible for their acts? Certainly 34, 35, 33 were responsible. Is there ever to be responsibility? They will also argue something in the realm of victim participation. We have rejected that. In fact, if her story was taken at its first version, the most, if it is even true, that this man did was agree to engage in sex with her. And that certainly doesn't justify or mitigate a killing. And then there's arguably what we call, like prosecutors call it, kitchen sink ground. So they're not statutory ground, it covers virtually everything else. In many instances, a plea for sympathy based upon a different packaging. Mental impairment is the defense of last resort. If you don't have facts or law to support your case, then as a defense attorney, you may find that some solace in the defense of mental impairment. But under the law, the real question is not whether Aileen Wuornos is a strange person, not whether she has a sour view of the world, not whether she had some unfortunate experiences as a young person, not whether she's explosive, exploitive, violent, and manipulative, and perverted. She's all of those things. She is all of those things. But the question is whether she understood what she was doing, whether she knew what she was doing, whether she knew what she was doing was wrong, and whether she chose to do it regardless of its wrongness and regardless of the consequences to herself and Mr. Mallory, and with a total disregard for his life as if it was nothing. The evidence that was presented by the defense, and the burden is never as great on the defense as the state. The state must establish virtually everything by evidence beyond a reasonable doubt. They have a lighter burden. But their evidence, the entire framework of this defense mechanism called mental impairment, almost in its entirety, with a few shreds of arguably supportive evidence, is based upon Aileen Wuornos' story and view of life and herself. Recall that these psychologists really had differing approaches, differing ways of reaching their conclusions, and considerably different opinions on a lot of different things, even as so far as whether simple greeting was an attempt to manipulate people. And that was kind of a light moment, but I use that to emphasize the fact this is really a field that certainly you can't call science. Don't know that we call it art. I don't want to label it, but it certainly is subject to considerable conjecture and potential for abuse, and fraught with real possibility, if not probability, of the individual feelings of the analyzer becoming the primary focus, because they decide which story to believe, whether or not they believe it all, or whether they believe everything. Well, what did Dr. McMahon believe? She received no report of a rape during the first 4-hour session that she had with Aileen Wuornos back in early 91. Then in March of 91, after a 6.5-hour session, she gets this first story, which is very consistent with what was told to the police. And then 9 months later, in December, she receives the fabrication that you had rejected in your verdict. The interesting thing about Dr. McMahon, she's the lady who testified first, she came to a conclusion that not one other mental health care expert came to, and that was she could tell if the person was lying by the tests. Not one of the other psychologists or Dr. Barnard, the psychiatrist, said that you could tell the person lying by the tests. And she went on to say that if in fact the story she finally accepted, and one Dr. McMahon based her whole opinion on, is the alcohol, rape, bondage story. That's what her whole thing is based upon. She took that as true. You have not. Dr. McMahon said if that story is not true, then she would have to start all over again and would probably have a totally different diagnosis. She also went on to say that whether Aileen Wuornos knew right or wrong at the time she killed this man was irrelevant. Very relevant. Dr. Croft demonstrated, I think, the uncertainty in the field for us. Also, the arbitrariness of these designations. He said if a child was 15 years and 1 day old, therefore that person wouldn't qualify. we all know that things subject to mental processes are not that cut and dry. That's where they lie. He said that she would, in fact, by him, be diagnosed with antisocial personality, except she set no fires before she was 15, which is would have given him the additional indicator, and that she was not a truant before 15. Well, the evidence in the files verified by the other psychologists and even on cross-examination, fires were set before 15, and everyone else found it to be a truant. But he wanted to bring in sexual innuendo. Remember, his specialty is sexual child abuse. That's why he was here. Dirty little innuendo against the family. And that's all it was. Dirty little innuendo. Not supported by evidence. Refuted by all the other psychologists. In fact, refuted by Aileen Wuornos himself. He went on to say that he would not find her antisocial, perhaps, because she displayed conscience. And then I cross-examined him on that issue. The fact is, he said that the story was not true of the alcohol rate. He would just call it that without getting into details. The alcohol rate. It was not true of effective diagnosis. Then we had Dr. Toomer from Miami. He told us that the biological mother died of cirrhosis of the liver due to alcoholism. Well, the biological mother is still alive. And in fact, you really imagine he was talking about the grandmother, but they were kind of trying to tie a genetic chain that through genetics, this woman is what she is. In fact, the son of the woman who raised Aileen Wuornos came in and told you that it was not cirrhosis of the liver, and there was no alcoholism in this woman. Another attempt to smear someone else to get sympathy for Aileen Wuornos. What he did tell us is that he never asked Aileen Wuornos one single fact about what happened. He came here to give you his opinion as to whether her mental condition affected her behavior, and didn't ask her one single question about her behavior. Not another mental health care expert used that procedure. And in fact, he said it would be unimportant. That in fact, if she had sat there coldly, deliberately, and intentionally killed and robbed, it wouldn't make any difference in his diagnosis at all. She's still a borderline personality. In fact, they all told us that she's borderline personality and had been since she was a teenager. And killing didn't have a whole lot to do with it. And that's precisely the point. Borderline personality didn't have a whole lot to do with it. She lived successfully 34 years in her own fashion. She's in her own way of life, but killed no one. Until she got a gun and decided that was a better way, the way she wanted to follow. What they told us was that she just doesn't think quite like most folks. Final, aggressive, angry. Did we need a psychologist to tell us that? Every one of you did that when you heard the evidence. That woman doesn't think like most folks. But that doesn't excuse her from going out and do whatever she wants to do, especially killing Miss Mountain. Finally, Dr. Barnard, the last to testify, mental health care experts, he was a psychiatrist as opposed to psychiatrist. He diagnosed her, yes, she said she had borderline personality defect, but her primary trouble was antisocial personality disorder. Something found in perhaps 1% of the female population. Everyone, without exception, of the mental health care experts, including Dr. Barnard, agreed that Aileen Wuornos at the time of killing knew right from wrong. That she knew the consequences of her acts and she was able to conform to the law, and that she was responsible for her acts and that she's not insane. That is not and has not been, nor will it be, disputed. So who is responsible? Aileen Wuornos says that maybe genetics, with no evidence whatever to support that. She says, through the psychologist, basically, that it's in her own testimony, it was her parents in the home that caused it. The evidence from others refute that, particularly the evidence from her brother. Remember, all of these histories that the doctors talk about, how she wasn't treated right, and there wasn't a great deal of abuse even in those histories. All abuse is spanked 5 times. Today's society, some people call that abuse. Maybe that's why we're in the trouble we're in today. But in any event, the only indication of anything in the home being wrong is Aileen Wuornos' story, fed to the psychologists who came to testify for her. She was disciplined, and she doesn't like that. She doesn't like discipline. She doesn't like responsibility. She even told her foster father, who had taken her in and cared for her just like the other children, "Can't spank me. You're not even my real father." She would even blame prostitution on others, although she told us that she liked the $60 to $100 an hour per event, a lot better than 75 cents an hour. And finally, she said Ty Moore was at fault. Must be her, because she was living off my money. Everyone but Aileen Wuornos is responsible, even the victim. Even the victim. In fact, that's where she is laid the blame. He has no.
I'm not sure why she's crying right at the moment. I mean, she was laughing yesterday. Hi, Netawell. Good to see you. I think, didn't you come in yesterday when or was it yesterday? Day before, Monday. I don't know. When she was laughing. Today she's crying. Yeah, I knew it was a short trial, Flashman. Just not for me. Not on my channel. We take the long way around. I think that boat trial was only like 4 days, and we're not even through day 2. Yeah, well, whatever. But I'm not sure why she's crying right now, and I don't know. Maybe she sees what's coming. And also, these closed captionings are almost pointless, but I'll leave them on. Absolutely. And they read out their names. When they did the verdict for the trial before the penalty phase started, they pulled the jury and read out all their names. Like, okay. Most of them are probably gone, but maybe not all of them. No pun intended, Flash fan.
Voice here except me. This is not a case about forgiveness. You can pray for her soul, but that's not what we're about here today. It is not about mercy. That is not what you will hear in the instructions. Mercy is simply another word for sympathy. And that's not what this verse is based on. We've had this long break, and we've had plenty of time. It's not based upon anger or a will to give it. It's based on the law that you heard. It's not even about mental illness, because every single mental health care expert that testified, if there appeared to be any indication in their testimonies based upon her stories, but they all agreed that she's responsible in every sense of the word legally. It's about a troubled teenager who refused to accept responsibility from the start and chose a lawless lifestyle, a cavorting, moralless lifestyle, and ultimately chose to kill. We began with 2 totally different stories. We began with 2 totally different views of the evidence. You're going to hear a totally different view in just a few moments. One view is based entirely and exclusively upon the misrepresentations of Aileen Wuornos. That is the basis for the defense in its entirety, from start to finish. The other view is based upon the evidence, the facts, and the circumstances as revealed by the evidence and the truth. Aileen Wuornos said he should die because he's cheating on his family. She's a prostitute. Said she had to kill him to make money to pay her bills. Go on to say, because the age made no difference, had no parents anyway. In her own words to Deputy Hanson, the lady that worked at jail that wasn't interrogating her for plenty of time for her to say whatever she wanted to say, not being cut off, She said, after I shot him, he just fell down and was saying, I'm gonna die. Oh my God, I'm gonna die. And Aileen Wuornos. Yeah, motherfucker. So what? And I shot him a couple more times. It became obscenely simple for Aileen Wuornos to kill. At one moment, Richard Mallory was here. And a few minutes later, by an act of her will, he was no more. It's not that he never existed. It's not that he never breathed and lived and hoped. It's simply that he was no more. By an act of her will, in just 15 or 20 minutes, she extinguished a man's life forever. And all that's left is a few pitiful possessions, junk, the junk of life, all that's left of a man. She told you, you saw her, her words, I'm guilty. I deserve to die. And you know that is the truth. Let your verdict and your decision with good conscience, with strength, and with integrity speak the truth. Aileen Wuornos deserves the ultimate penalty provided under the law of the state of Florida. Thank you.
Good morning. Ladies and gentlemen, this is perhaps one of the most difficult tasks I've ever been required to do. I must ask you to save Aileen Wuornos. I must convince you that she should live. It's a difficult task for me because just asking another person not to ask for the life of another human being is so extraordinary. It's so far from the commonplace that all of the knowledge and tools that we use in our everyday life are simply not available to us. It's difficult because how do I explain? How do any of us explain what it's like to see things as Lee does? How do people who are presumably normal, who are presumably unimpaired, how do they understand what it's like to live impaired? How do I make you understand that everything that Lee feels, does, and says is filtered through that disorder, through that impairment? Everything must go through that filter. She is not like the rest of us. Once there was a verdict of guilty, I started trying to think about what to do. I tried to pull together all of my life experiences and knowledge that I gained over the last few years to try to assist me in doing this. And frankly, I have found that it's just not enough. I don't know what to do or say to convince you that Lee should live. I only know that she should. You have necessarily learned about Lee Wuornos in a vacuum. Everything that you know, everything that you believe about her has been gained from this witness stand. For a brief moment in time, you got to meet Lee Wuornos under situations that, if you listen to the testimony of the experts that came in here, was very, very stressful. They told you what happens to Lee when she is under stress. I can't tell you what the three of us have learned about Lee over the many hours that we have spent with her. You must decide whether Lee should live or die based on what you have seen and what you have heard in this courtroom over the last few days. That decision will probably be the most significant and most difficult decision that any of you will ever have to make. Please understand that those of us seated at that table understand that. And we appreciate how hard this must be. But also understand, when you're trying to make a decision, that the laws of this state embrace the concept of mercy. If you feel that Lee is deserving of mercy, you can vote for mercy. Mercy for Lee is life in prison. Ladies and gentlemen, we're here today because late one night in November of 1989, Richard Mallory and Lee Wuornos met on the side of a highway here in Florida. We've all been in this courtroom. We know that that was a tragic, deadly meeting. All of us are asking why, but why did it have to be that? Perhaps the answer to that can be found by going back to that day years ago when Lee, as a young girl, stepped to the side of the road and stuck out her thumb. She had no direction and not a single hope in sight. She carried with her the baggage of abandonment, the forfeiture of a child, of a baby when she was still just a child. She carried with her the inability to figure out how to make it, how to do anything at all to satisfy her basic needs. All of the experts agreed on that. She didn't know how and does not know how to satisfy even the most basic needs. From one ride to the next, and to the next, and to the next, all the way until January of last year. She traveled through this world, always on the out.
I don't quite get it. There's been a lot of bad things in here that I would have thought she would have broken down about. I guess maybe hearing somebody talk about your life like that sometimes just gets to you. But it's just a weird time for her to break down. For me. Well, then you are special because earlier, what did I try to say, Flashman? It was not bad. I don't even remember what it was. I had to type it in like 4 different lines just to, I think I said something about watching something. Like, nope. That time I said, I hope she lost a crimp in her hair. Which is probably why I didn't like that one, but whatever. Tater tot day in the jail. Maybe that's why Taylor Shabiznes got so mad last week, whenever it was. They could have been in jail together with Sarah Boone. Oh my. Yikes. Oh, yeah, I was saying that Connecticut trial would be interesting to watch. Strike me down. That's horrible. Don't say such things. I don't know. All right. The jurors aren't even looking at her, crying. Wonder if they glanced. Was it the pork sarnies that one judge said wasn't to miss? I don't know. Some jails have really good cooks. I think a lot don't. Don't know. Never been in one. Not as a visitor or in custody.
Outside, traveling through a place in which she has never, ever had a place. She has been living in a world that to her perception is violent and frightening. From that time way back, when she was a little girl, she has been burdened with an impairment or a disorder that makes her intensely needy, makes her intensely afraid of being abandoned and being alone. And yet at the same time, causes her to act in such a way that she will not allow anyone to get close to her. The very impairment, the very disorder that makes her need so desperately prevents her from ever having the satisfaction of fulfilling those needs. You heard the doctors talk about what Lee is like and what she experienced. If you will recall each and every one of them, and that's even the expert, Dr. Barnard, that was called by the state, said that people who suffer from the disorder that Lee suffers from live an ungratified life. They never feel successful. They never feel satisfied. They don't go home at the end of the day knowing that they have reached their fullest potential because she has no idea what her potential is. She doesn't know who she is. She doesn't know what she's all about, and she can't control what she's all about. She's always alone, and she's always frustrated. Dr. Toomer explained it to you, and he said, what Lee is all about is someone feeling that I don't deserve anything good. I don't deserve to be liked. I'm not worthy. And so what she does, because of her impairments, because of her disorder, a disorder that each and every one of the experts told you she had no control over. She didn't ask to be that way. So what she does is when she comes into contact with another person, she's thinking, I'm not any good. I don't deserve their friendship. They're going to be mean to me. They're going to be rejecting me. And she acts out in such a way that will fulfill that prophecy, will validate her thoughts so that she can say, see, I was right. No one was going to like me. No one was going to want me. Remember what Dr. McMahon said. I think that was a very, very important description of what Lee's all about. She is a damaged, primitive child. Dr. McMahon told you that she has never seen anyone that primitive outside of an institution. But we all know, we've all had the experience of being in this courtroom for the last few weeks. We know that, yes, there was at least one other primitive, damaged person that was not in an institution, and it was Lee. And she was working from one exit to the next. She was out on the road, fulfilling some basic needs. and assisting in supporting her friend, the only friend she ever had, and engaging in a destructive, dysfunctional relationship. You've heard that that's all she's ever had. She doesn't know anything different. All of the experts told you that Lee views this world as a very, very unhappy place, that she feels persecuted, that she feels that people are against her, that she reacts to the stimuli in her environment. She has no control. Everything happens to her. She is a person who thinks that pain and unhappiness is inevitable. She doesn't understand. She doesn't know. She doesn't have the ability to control that. The doctors have all told you that she experiences severe mood swings. You've heard that testimony. You've also had an opportunity to see that. They told you about a person who could laugh and cry and get explosively angry, and who always experiences intense emotions. You've got to see it. You've seen it. Remember when Dr. Croft was testifying? Do you remember who Dr. Croft was? He was the gentleman with the beard, kind of salt and pepper hair. He was telling you that Lee is 1 point away from borderline retardation. And she began to laugh. And she began to giggle and be silly, like a little girl. And Dr. Croft explained why that was happening. It's because people that suffer from what she suffers from can never, ever admit that there's anything wrong with them. That they spend their life trying without success to show people that they're all right, that they're okay. They have defenses that they build up. And Dr. Croft said something. He said that the reason people like Lee, who suffer from personality disorders and brain impairment, hold on so hard and so fast to their disorders is because of the pain underneath. They can't ever let that pain be exposed. All of the experts explained Lee's life in the terms of she's on a roller coaster, rapidly moving from one moment to the next, from one mood, and no control over it, laughing in the courtroom, being angry in the courtroom for seemingly no reason, not being able to let anybody help her, not being able to make anybody like her, always turning on the very people that are trying to help her. All of you have seen that in this courtroom. And she has no control of that. She doesn't choose to be that way. What is important about Dr. McMahon's testimony is that she said that Lee, like other people who suffer from personality disorders, see other people coping. They see other people being able to satisfy their basic needs, but they can't figure out how to do it for themselves. So they suffer the anxiety and frustration of realizing, but not being able to do anything at all about it. What you have seen in this courtroom and what the experts have described are human beings like Lee, who within seconds go from depression, laughter but never happiness, and emotional withdrawal. There have been times when it was almost as if Lee was not in this courtroom. You must have seen the times when she had withdrawn to such an extent that you might have wondered, what is this all about? Why? You also have learned that Lee can't control her impulses, and I think all of you have been able to see that. And how frustrating that must be. all of the doctors, all of the experts that testified in this courtroom told you that in forming their opinions, they reviewed investigative reports. They reviewed Lee's school records. They talked to certain people. They read taped interviews of people who had known the family and known what life must have been like back in those days. And without fail, even the state's expert, Dr. Barnard, told you that one of the things that they agreed on, and actually they all agreed, was that Lee came from a dysfunctional family. I think that perhaps the best evidence that Lee comes from a dysfunctional family was her brother, uncle, Barry Wuornos. He was called by the state and he took the witness.
Hey, she she said it too. I just said it the other way because first he was her uncle, then he was her brother. But she said brother uncle. I'm not crazy. Not yet. I can't prove it.
Stand. And he told you that life was good. Life was okay. Dad was great. Lee didn't have any problems. There's never any discussion of Lee having problems, Lee not being able to get along. Then in her teens, yeah, she probably started having some problems, but remember, he was gone. He had left home when Lee was somewhere between 9 and 10. And think about that testimony and then remember what the experts have told you. They had told you that they had reviewed her school records and that her school records show that she could not hear. She was having hearing problems, that the school was asking for help for Lee, and that her mother, the person that Lee has described as being the angel, responded by saying, she can hear. Lee just doesn't want to follow directions. Remember that she has had visual problems since she was a small child. That's documented in her school reports. But Barry said that Lee was fine. Remember that her school records, now we're talking, we're grade school. Remember, she quit school in the 9th grade. And grade school records show that they were medicating her with tranquilizers to try to make it easier for her to function in a world, in a classroom where she has never, ever had a place. And the brother says, no, Lee was fine. There weren't any problems. Remember what the doctors told you about the cousin, Mr. Lightela, who considered Lee's grandfather to be an uncle that he wanted to spend time with. And they told you that he spent a good deal of time in their home. And he described Lee's grandfather as a Jekyll and Hyde. He described a man who, when he drank, could be abusive and was very, very different than the person that Barry described to you. Remember that Barry, Lee's uncle, brother, ultimately she found out he wasn't her brother, came into this courtroom and testified against Lee in a proceeding in which the state is trying to kill her. He testified against her. What does that tell you about how dysfunctional that family must have been and still is? What better evidence do you have of a dysfunctional family? Remember the subtle things he said about what that family was all about. He testified from the stand, and I wrote it down. Their adoption was a sore point within our family. He described the siblings as Barry and Lori, natural children, were good. Lee and Keith were bad. And it was a sore point in that family. What does that tell you? Ladies and gentlemen, Richard Mallory is dead. And that is a terrible, terrible thing. We are not asking that you forget that. I submit that each of us feel that all of mankind is somehow diminished when we learn that a person has died at the hands of another. I suggest that all of us feel confusion and pain, and we feel like something has gone awry. We all suffer a loss. We are not asking you to forget that or put that aside. Richard Mallory is dead, and he should not have died. What we are asking that you do is to consider the circumstances of his death and consider Lee's involvement in light of who she is, in light of her history, her lifestyle, what she was perceiving. Do not evaluate Lee's actions on that night in terms of what another person may or may not have done. This is about Lee. That is what these proceedings, these second phase proceedings have all been about. This is about Lee. Lee, who dealt with her experience with Mr. Mallory with all the sophistication and understanding and insight of a damaged, primitive child. Do not judge her by what another person may or may not have done. The experts explained to you, or tried to explain to you, who Lee is and why she responded the way she did back in that early morning hours of December 1st of '89. They've all told you that she suffers from minimal brain damage. They've explained to you that her disorder causes her to live an unfulfilled, frustrated, paranoid, persecuted, unhappy life. And I want to make sure that you understand that we are not offering these as excuses. We are not telling you that she's not responsible. She told you she was responsible. She killed him. But understand, in her mind, by her perceptions, she thought she was in danger and that she was threatened, and it was the only thing to do. These, again, are not excuses. We offer them as explanations and reasons that you can consider when trying to make a decision as to whether or not Lee should live or die. They're not excuses. There is no excuse. And we are not asking you to forget Richard Mallory. All that we are asking is that you take all of this into consideration before you make your decision. We all deserve that. You, as well as everyone that's been going through this procedure. You need to know the person before you can make a decision like you've been asked to make. The judge will instruct you that if you are reasonably convinced that Lee was under the influence of extreme mental and emotional distress at the time that Richard Mallory died, that you can consider that a mitigating factor. You can consider that as a reason to vote for life. The judge will instruct you that if you find or are reasonably convinced that Lee's ability to appreciate the criminality of her conduct or conform her conduct to the requirements of law were substantially impaired, that is something that you can consider as a mitigating factor, a reason to vote for life. You will hear that you can consider virtually anything about Lee and the circumstances surrounding this offense as a reason to vote for life. Mr. Tanner, in his closing, told you that mental impairment is a defense of last resort. It's what defense lawyers do when they don't have anything else. Well, that is not true. Defense lawyers take their cases as they come, and they have a moral and an ethical obligation to raise those defenses that are apparent. Lee is impaired. She's dysfunctional. She suffers from a personality disorder. We, yes, raised it. And we raised it because it was proper, because it was right, and because it was our obligation to do so. It is not a last resort. It is the truth. Mr. Tanner told you that, interesting, isn't it, the way the experts all have a different way of, a different approach to handling the same situation. Recall their testimony. Was it really so different? But most importantly, recall that they all came to the same conclusion. Remember that the doctors said that what really happened, the truthfulness of Lee's description of what occurred on that night, was not really relevant. What was important in light of her dysfunction and her impairment was what she perceived. That's what was important. And they told you that without even knowing the facts of the case, their diagnosis would be the same. Mr. Tanner tried to diminish Dr. Kropp's credentials and his credibility by telling you that the reason he was called is because he is an expert in sexual dysfunction. Dr. Kropp, if you will recall, has had years and years and years and years of experience in forensic psychology. He told you that as a subspecialty, he dealt in sexual dysfunction. Well, certainly he had an opportunity to evaluate someone who fit into both of those categories, and that is why he testified in this courtroom. Again, please understand that these are not excuses. There is.
We're not even any scores flashing. The scores are even. They're all even. Hey, Pedaltown, how are you doing? Nice profile picture. I can tell who you are today, at least for the time being. Oh, I see what you're doing. All right. I don't know who this is. Merry Christmas. Yeah. I didn't know what you meant by even the score. I was like, please don't do anything. I might not be able to fix it.
There's no excuse. There are reasons for you to consider when trying to make a decision as to whether or not Lee should live or die. Do not be deceived into thinking that life imprisonment is not punishment. I suggest to you that one of life's ultimate gifts is freedom. I suggest to you that if a person were locked forever and let's say a mansion, that they would suffer agony every time they looked out the window with the knowledge that they could never go outside again. Consider the prospect of terminal confinement. The judge will instruct you, and you will hear that a sentence of life imprisonment is a sentence of life without possibility of parole until after serving 25 years. That is a mere possibility. Life in prison is severe. Every second of every minute of every hour of every day of every week of every month of every year, Lee will be confined. Someone else will tell her when to go to bed and when to get up. Someone else will tell her when and what she can eat. Someone else will tell her what she can read. When she longs for the comfort of human touch, she can't have it. She will be separated forever from the freedom that she has known since she was a young girl and began to travel freely across the country, sadly unrestrained by the restrictions that keep all of us close to home. She has been free out in the open for most of her life. She will go to sleep every night in a metal cage, surrounded by the sorrow, the heartache, and the bitter loneliness of others. If she's lucky, she'll have a window. If she's real lucky, that window will give her a view instead of just more metal bars and razor wire, will give her a view of the world outside. And every time she looks at the outside world, she is going to remember what she did to lose it. Her longing, ladies and gentlemen, will always bring her pain. Lee lost her freedom in January of last year. I suggest to you that, as with all human beings, though, she has maintained some degree of hope. I suggest to you that there has always been the belief that somehow, and it was a childlike belief, somehow everything will be all right. Well, in the last couple of days, Lee has had to accept that nothing will ever be all right again. Ever. When she leaves this courtroom for the last time, she goes without hope. Whether the sentence is life imprisonment or death, Lee has lost her life. Even if you are merciful, you will simply be giving her the mere right to exist. Please go back there. Please go back and decide that that is punishment enough. Thank you.
Aileen Wuornos, also known.
All righty. That was a funny typo, Gabby. I don't know how that happened. I retract that statement. All right, I'm not going to play the 10 minutes of jury instructions. I am going to go here. Stop it. Oh my goodness. We have closed captionings again. Did not have that on my bingo card today. Gabby, I was thinking about you. We have, I think it's because of all the rain we've had, those little teeny tiny ants that come in. So like, if you drop like a drop of like juice or something on your counter, you don't realize it, that they just form a freaking freeway too. I haven't had them that bad, but I've been dealing with them since the weekend, and I saw one today and I was like, I'm about to unalive you, you bastard. Like Dawn power wash in the spray bottle gets them right instantly, and it cleans your wall. Adios, Puddletown. We will be here for a while. Just telling ya. Valor comes on here in a minute. Yay. All right. We got the verdict. We get the sentencing.
Madam Clerk, we need questions.
In the Circuit Court, 7th Judicial Circuit, in Volusia County, Florida, case number 91-257, State of Florida versus Aileen Wuornos, also known as Susan Lynn Blahovic, also known as Lori Christine Grady, also known as Tammy Marsh Green. As to count one, the majority of the jury, by a vote of 12-0, advise and recommend to the court that it impose the death penalty upon Aileen Wuornos, also known as Susan Lynn Blahovic, also known as Lori Christine Grady, also known as Tammy Marsh Green, dated at DeLand, Volusia County, Florida, this 30th day of January, 1992. Pamela J. Mills, foreperson.
Ladies and gentlemen of the jury, we're going to ask each of you individually concerning the advisory sentence. It is not necessary that you state how you personally voted or how any other person voted, but only if the advisory sentence read was correctly stated. Madam Clerk, will you please vote?
Do you, Mrs. Staton, agree and confirm that the majority of the jury join in the advisory sentence that you have just heard read by the clerk? Do you, Mrs. Farrell, agree and confirm that a majority of the jury join in the advisory sentence that you have just heard read by the clerk? Do you, Mrs. Mills, agree and confirm that a majority of the jury join in the advisory sentence that you have just heard read by the clerk?
Yes.
Do you, Mr. DeGainer, agree and confirm that a majority of the jury join in the advisory sentence that you have just heard read by the clerk? Do you, Mrs. Mathis, agree and confirm that a majority of the jury join in the advisory sentence that you have just heard read by the clerk?
Yes.
Do you, Mrs. Walters, agree and confirm that a majority of the jury join in the advisory sentence that you have just heard read by the clerk?
Yes, I do.
Do you, Mrs. Wiley, agree and confirm that the majority of the jury join in the advisory sentence that you have just heard read by the clerk?
Yes.
Do you, Mr. Flowers, agree and confirm that a majority of the jury join in the advisory sentence that you have just heard read by the clerk?
Yes.
Do you, Mrs. Bowman, agree and confirm that a majority of the jury join in the advisory sentence that you have just heard read by the clerk? Do you, Mr. Watley, agree and confirm that a majority of the jury join in the advisory sentence that you have just heard read by the clerk? Do you, Mr. Aransky, agree and confirm that a majority of the jury join in the advisory sentence that you have just heard read by the clerk?
Yes.
Do you, Mr. Bashal, agree and confirm that a majority of the jury join in the advisory sentence that you have just heard read by the clerk?
Yes.
Thank you all.
Any further questions here for the charge?
Nothing but the state, Your Honor. Thank you. No, Judge, thank you.
Ladies and gentlemen, I want to express to you and thank you very much for your time and consideration for this case. I also wish to advise you of some very special privileges that are enjoyed by jurors. No juror can ever be required to talk about the discussions that occurred in the jury room except by court order. For many centuries, our society has relied on juries for resolution of difficult cases. We have recognized for hundreds of years the jury's deliberations, their statuses, and their votes to remain their private affairs so long as they wish. Therefore, the law gives you the unique privilege not to speak about the jury's work. Although you are at liberty to speak with anyone about your deliberations, you're also at liberty to refuse to speak to them. A request may come from those who are simply curious or may seek to find fault with you. It will be up to you to decide whether to preserve your privacy as a juror. With those instructions, the jury is in recess and discharged from further obligation and responsibility herein. Notice is scheduled for 9:30 a.m. tomorrow morning. Mr. Pitt, if you let us work the jury out.
Judge, before you leave, we would renew all previous applications and motions and extensions. Thank you, Judge.
The order that we're here about that. Recess tomorrow.
Thank you, Your Honor.
Judicial Circuit is now in session. The Honorable Judge Uriel Blunt Jr. presiding. Please be seated. Quiet in the courtroom.
I have no idea what's happening.
Docket number 91257, the state of Florida versus Aileen Carol Wuornos, also known as Susan Lynn Blahovic, also known as Laurie Christine Grody, also known as Kemi Marsh Green. The court is prepared for sentencing. Does the state have any witnesses like to present at this time?
Your Honor, we have no witnesses. May I make a brief statement?
Yes, sir.
Your Honor, I'm not going to insult the intelligence or the wisdom or the perception of this court by going into any type of a detailed recounting of the facts and circumstances which brings Aileen Wuornos before this court at this time in this county. I would like to discuss just for a moment or two a couple of aspects of the law and why, in fact, the state is urging the ultimate penalty permissible under Florida's law for Ms. Wuornos. First, I say to you sincerely that this is probably, for every prosecutor, the most difficult assignment that our office faces, and that is the studied and considered decision to first ask the citizens and then ask the jurist to permit the law which requires the forfeiture of a human life to be activated against another citizen. It is not only of great and considerable legal weight, but I can tell you from a personal standpoint, and I speak for my staff, it is a great emotional drain upon all of us involved in a case like this. Nonetheless, the people of the state of Florida, through their elected representatives and through well-documented and voiced opinion polls over the years, as the people of this nation, believe that there is a place in our society, a necessary place in our criminal jurisprudence for the death penalty. Rare are the cases of murder on the grand scheme of the number of murders committed nationwide in which the death penalty can be fully and unequivocally justified. This is one of those cases. The aggravating circumstances, I'll not recount them. They were argued and the court instructed upon them, have been proven, Your Honor, beyond and to the exclusion of any reasonable doubt. The unanimous verdict of this trial jury, and I can say this, that they took the time to deliberate and return a unanimous verdict, which I think is a clear indication of the completeness of the evidence and the propriety of the sentence of death. I would ask you to not only sentence Aileen Wuornos to be electrocuted, I would ask that with regard to the additional sentences that the maximum penalty be imposed. We know that under the law, the 3-year minimum mandatory as part of the robbery sentence is called for by statute. No exception for that, even in a murder case where a weapon is used, and I refer specifically to Chapter 775. Under the case law, and I cite Williams v. State, and I have a copy we provided already to defense counsel, Your Honor. The imposition of the minimum mandatory is appropriate, and that is at 517 Southern 2nd, 681, Florida Supreme Court, 1988. Also,
Even if the weapon was a part of the statute?
we believe that is correct, Your Honor, under the Williams decision. May I into that case? Defense counsel has already been provided these cases. In addition, we're asking you to depart from what the sentencing guidelines, which I believe has been one of the greatest impediments in the state of Florida to the fair and appropriate administration of criminal justice, and has directly resulted in the diminution of the respect for the bench and for the law in this state. Nonetheless, we are still bound by them, and we, and certainly like yourself, Your Honor, will abide by sentencing guidelines so long as they remain a part of our law. But a departure is appropriate in this case from what the guideline sentence would permit to a sentence of what the statute would allow, and that is life imprisonment. And for the authority of that, I would refer, Your Honor, to the state case of Hansbrough v. State, 509 Southern 2nd, 1018, as cited in Rutherford v. State at 545 Southern 2nd, 853. And if I may also provide the court with that case. Case essentially indicates that the forms that the legislature and committees developed under the sentencing guidelines provisions of the law simply don't include a category for a conviction of murder in the first degree to be considered at the time. And under the cases cited, the Supreme Court has upheld, in effect sanctioned, a departure for a sentence exceeding the guidelines up to the maximum statutory allowable. Also, if Your Honor please, with regard to the legalities of where we are for a moment, we would ask you to retain jurisdiction in this case for several matters. One, count 3 was severed at the bench just as the jury selection began. We would ask you to retain jurisdiction until count 3 is disposed of. There may come a time that discussions between ourselves and the defense will result in a resolution without litigation. We certainly hope that. We can only offer what we believe would be a fair resolution. We will do that at some time in the future. In addition, the state of Florida and the people of Volusia County particularly are entitled to reasonable and full cost assessment. We have not yet had an opportunity to compile those figures in their entirety. The bills from the mental health care experts have not been submitted. Bills for expedited depositions that became necessary because of the lateness of some of the experts' testimony, including their refusal to honor subpoenas from this court, resulted in many late-hour depositions and expedited printings of depositions. So we cannot come to you with those figures at this time. I'd ask you to retain jurisdiction for that. And in connection with that, the rule to show cause motions which have been filed, which you don't want to argue or present at this time, with regard to Dr. Elizabeth McMahon, Dr. Jethro Toomer, for their refusals to comply with subpoena. Not meant as a vindictive measure, Your Honor, but only to hopefully bring an orderly procedure to cases in the future where we deal with that particular profession, and more specifically, those particular professions. The housekeeping matters behind, I would only say in closing, this is the only time that I've stood before this particular jurist and asked you to enforce, uphold, and pronounce a sentence to take another person's life. I don't do it lightly. I can tell you I do it with a heavy heart. Aileen Wuornos has come into this courtroom with an utter disregard, continuing for the truth, with an utter disregard for the destruction she has wrought upon her victims, and with a continuing utter disregard for even the reputation of her very family, her deceased mother and father. Her acts of murder and of total, absolute, unwavering determination to avoid and deny responsibility continue even to this date. I ask you to sentence her to die in Florida's electric chair.
Mr. Chandler, you have a
In the elected chair? I thought, okay. For some reason, I thought it was an injection. It's weird. Zach, your Aileen Wuornos did not show up in StreamYard chat. That's weird. This guy's voice is even bored listening to this guy's face is bored listening to his voice. He's got a heavy heart. Don't make fun. Yes, they want her to become a politician. And the elected chair. All right.
a guideline score sheet for me.
Yes, Chair. These two. Yes, Your Honor, I do.
Has a copy been made available to council?
That's what I was asking. Is the council a copy to make? Your Honor, may we step out and make a
Yes,
copy?
sir.
I apologize.
Well, let them view that one, then we can file it with each other.
That copy is.
Ms. Wuornos, when I have completed my task here today, you will begin the first day of the rest of your life. The curtain will fall on the tragic drama of the trial of Aileen Wuornos. Tomorrow's sunrise will bring the beginning of the appellate procedures as provided by law, and I will return to pasture. You have been convicted by a jury of your peers of the offense of first-degree premeditated and first-degree felony murder and armed robbery of a firearm and Richard Mallory. Do you or your attorneys who stand to your side have any legal cause to show why the sentence of law should not now be imposed upon you? Do you have any matters in bar preclusion sentence? Do you have any matters in mitigation sentence that you would give the court at this time?
We have certain matters we'd like to bring up, Your Honor.
Yes, sir.
First, we would ask that Your Honor hear from Ms. Arlene Crayley.
Certainly. So the court reporter can hear you, will you speak loudly enough and also give her your name?
Yes, my name is Aileen, Pralle.
I won't have time to do it today, but boy, is there a story about that woman. Little scammerson, I think.
I'm sorry. I was going to say, Ms. Pirelli has certain matters that she would like to relate to the court. I think this is your opportunity to speak.
Certainly.
Okay, Your Honor, my husband and I adopted Aileen Wuornos on November the 6th. We heard in this courtroom 3 expert witnesses in the field of psychology who said that Aileen Wuornos, though 35 years physically, was emotionally and psychologically a child. Dr. McMahon referred to her as the most primitive one she had ever seen other than within an institution. My husband and I have spent as much time, if not more, than all of our experts combined. We are 100% behind their diagnosis, and I would plead for mercy for my daughter's life because she never was given the chance to grow up. She is still a child, as they have said, and there are 2 factors I think that are very important. Her school records indicated, as well as the experts, that Aileen Wuornos, from a very young age, wanted the structure of a very tight family. She longed to have that, a nurturing environment. And the school records also indicated that she was in need immediately of counseling, immediate. Those were never granted. Both of those factors are now present this day in 1992. She has a family that cares about her, that loves her unconditionally. And we are also, Your Honor, if you would give mercy, in this case, we are willing to pay for the professional counseling that Aileen Wuornos should have received as a child. And I just plead for your mercy for my daughter's life.
Thank you very much, ma'am. You may return to your seat.
Judge, as to the show, a couple of technical matters, as to the show cause issue that Mr. Tanner mentioned, we would like an opportunity to be heard on that.
Shall.
I take it today is not the appropriate time.
I think not.
Yes, Judge. As to the proceedings as a whole, we review our previous motions, objections, and applications. We do have certain brief comments, and I think Ms. Wuornos has certain brief comments as well. You want to go first?
Yes. Okay. First of all, I'd like to say that I have been labeled a serial killer, and I am no serial killer. I've been framed by the law enforcement as a serial killer because of numerous men involved. But what I was a prostitute. And in my prostitution, I happened to deal with a lot of men, at least 200, 250 men a month. And I ran into these men along the way in my prostitution. I do not feel, I was not out there to hurt anyone. I had no intentions of hurting anyone. In my confessions, I stated that 9 times. I stated 37 times self-defense, 39 times that they raped or beat and then begin to rape and had intentions of killing. And what I did was what anybody else would do. I defended myself, which everybody has the right to defend themselves. And I had no intentions of killing anyone. I would not do that. I'm not that type of person. Anyway, what I'm trying to say here is that while I've been through this 2.5 weeks in the courtroom, I told you that I was raped, and that is what happened. And that is what happened with all other cases that I'll be involved in and discussing. And these people did a violent attack on me, and I did what I had to do to protect myself. Now, I'd like to point out one other thing, is that the law enforcement has framed me as serial killer purposely for books and movies. And I have been, since I've been incarcerated a year in jail, have gone through a lot of physical and mental abuse, which I felt is being a conspiracy through the law enforcement. And I also believe the law enforcement and the state attorneys have a conspiracy here. And I have to say another thing, for as far as manipulation was talked about yesterday,
in the courtroom, I believe State Attorney Tanner was the one manipulating the jury, which he had made a whole lot of things up. Things were just made up at the top of his head, were not true, and I felt that he lied right through his teeth. I was up in that stand there, and I did not lie. I was coerced into making my confessions. I was threatened that Tyra Moore would be arrested if I did not talk about the confessions. I was also coerced and threatened and told that if I did not answer their questions the way they wanted me to, their questions, and I did it any other way, that she would be arrested. And the questions that they asked me were strictly to implicate me as a serial killer, when every time I talked about a rape, they cut me off, and they had my mind all messed up, where I was hysterical, I was in trauma, and I was alcohol withdrawing. I have been totally under duress and delirium, and I couldn't tell you what happened anyway. I couldn't remember anything under that stress. All I had in my mind was focused on Tyra, which I was trying to clear Tyra, which Tyra knows it's self-defense, and she's lying through her teeth, telling that she doesn't know anything, even the smallest of things of our life together, 4.5 years, and she does know. She knows it's self-defense, and she's been offered like $500,000 and might be a multimillionaire after this is over, and she's just keeping her mouth shut because she wants money. They have to have a conviction in order to get this money. And that's all I got to say. I'm not a serial killer.
Your Honor, we have some observations. I guess I should go first. Or maybe I could make some observations for the three of us. Mr. Tanner provided to Your Honor some personal views as to his understanding of his position here and the difficulty that he has, and I think that's legitimate. I really do think Mr. Tanner finds this role very difficult. Hasn't been easy for us either. It has been a difficult task when you're litigating over the life of a fellow human being. What I would suggest to Your Honor, and we will not go through aggravators and mitigators and rehash the evidence. Your Honor has heard it, and like Mr.
I need to speak again.
Yes, ma'am, you may.
Okay.
You want to wait till we get through, or you want to talk now?
I just wanted to make sure he wouldn't cut me off.
Go ahead now.
Okay. What I'd like to also say is that we had 2 clients that were willing to testify for me, that we did not bring the mitigator factors in, and I was surprised that my lawyers had me just testify on the stand and then said, the defense rests this case, because I did not know this was going to happen. We had a police officer that was going to verify that they misused evidence and that they falsified reports. None of the evidence, all the evidence on the floor, there was half of the stuff was mine. And there was a radio on the floor that one of the victim's family said, yeah, that's mine, and it isn't. It was our radio, and Tyra knows that. And I'm sure I could get a witness to verify that radio I had before Richard Mallory was ever killed. And I kept all the weapons in storage. None of the weapons were on the floor for proof if I ever got busted, that I could prove that these guys used these weapons on me. None of the weapons were on for evidence. And we had 2 clients. We had a police officer. There was also, I had high school friends, at least 15, that I wanted contacted. They were not contacted. This case did not, for me to testify for myself, it seemed like I got a total raw deal. I should have had, my clients should have went up. That officer should have went up. I should have had my high school friends testifying for me. I couldn't believe I just got in that stand for myself. And I was telling the complete truth. I was being as honest as I could be.
Thank you. Mr. Nolis, you may proceed.
Yes, Your Honor. What I was going to say is just to give to Your Honor some personal observations.
Certainly.
Your Honor has a very difficult job here. You've been on the bench quite a long time, and you've seen, I dare say, quite a lot more than the 3 of us combined. It is a task that we do not envy, and that hopefully none of us will ever be in a position to make. I know I never want to be in a position to make the type of decision Your Honor needs to make here. We, as a people, can decide to impose the death sentence on Ms. Wuornos. We can decide to have her executed. Those procedures, as Your Honor know, are about as cold and calculated and premeditated, using those terms, as any procedures can get. It's done with a great deal of formality, with a great deal of calculation. What I would suggest to Your Honor is that such a sentence would meet none of the goals that we consider to be penologically appropriate. No one would be deterred by a death sentence on Ms. Wuornos. Surely rehabilitation is not at issue. And the only question is really retribution. And the question is it worth the thousands and millions of dollars that it's going to take to have Ms. Wuornos executed? Is it worth us as a society? Is it something we should do? We can do that. If we were to do that, we will be doing something, and I would submit to Your Honor that we will be accomplishing nothing. And with that, Your Honor, I guess
Ms. Jenkins, Mr. Miller.
I have nothing to say, Your Honor.
All right, the defendant, Aileen Carol Wuornos, being before the court, attended by attorney Tricia Jenkins, William Miller, and Billy Nolis, her attorney of record, having been tried and found guilty of crime count 1, a first-degree premeditated murder, and first-degree felony murder of Richard Mallory, a capital felony, and count 2, armed robbery of a firearm, armed robbery of Richard Mallory with the firearm, and no cause being shown why the defendant should not be adjudicated guilty, you're hereby adjudged guilty of said offenses. You will be, as required by law, compelled to pay $20 to Crimes Compensation Trust Fund and $5 in accordance with Florida Statute 943.25, subparagraph 4. I've reviewed your affidavit of indigency, find that you're unable to pay costs, and accordingly all costs are hereby waived. As to count 2, the sentence is imposed in accordance with the guidelines mandated upon this court by the state of Florida. The defendant, being before the court, attended by her attorneys Tricia Jenkins, William Miller, and Billy Nolis, having been adjudicated guilty herein, and the court having given you an opportunity to be heard and offer matters of mitigation of sentence, no cause being shown. The sentence of the law and the judgment of this court that you, Aileen Carol Wuornos, be imprisoned by confinement, committed to custody Department of Corrections for a term of 10 years from this date, with credit for times heretofore served in the Volusia County Jail. And you will be compelled to serve a 3-year mandatory minimum as provided by Florida Statute 775.0872. That's in count 2. As to count 1, you will be required to make restitution as entered by a separate order that I am signing at this time. As to count 1, the defendant Carol Wuornos, being now before the court, attended by her attorneys Tricia Jenkins, William Miller, and Billy Nolis, and having been adjudicated guilty of the crime of first-degree premeditated murder and first-degree felony murder, a capital felony, and the court having given the defendant an opportunity to be heard and to offer matters of mitigation sentence and to show cause why the sentence of law should not now be imposed upon you, and no cause being shown, filing with the clerk my written findings in this matter. Copies will be made available to the council when they're available. It is a sentence of the law and the judge of this court that you, Aileen Carol Wuornos, be delivered by the sheriff of Volusia County, Florida, with a copy of this sentence forthwith to the proper officers of the Department of Corrections of the state of Florida, and by him safely kept until, by warrant of the governor of the state of Florida, you, Aileen Carol Wuornos, be electrocuted until you are dead. And may God have mercy upon your court. The judgments and sentences will be entered in open court this 31st day of January, 1992, and my signature attached. The court does not advise you that you have the right to appeal the judgment and sentence imposed upon you, and upon showing to the court of your desire to appeal the judgment and sentence, and should you be an indigent person, counsel will be appointed to represent you for the appeal purposes. Will you please step over to the bailiff for fingerprinting, ma'am? This way, I think.
Why didn't he say, may God, he didn't say, may God have mercy on your soul. Didn't he say, may God have mercy on your court? Oh, StreamYard, quit it. I don't know what's happening. I have too many windows open. I know. Sorry. Everyone's been buffering lately. Me and she's apologizing for throwing him under the bus.
Thank you, Judge. Take care.
You're always great. Well, there we have it. Oh. So, by lethal injection. That's what I thought. I didn't think she got the chair. Stop. Don't say a word. She did. She made a comment. Let me see if I can find her final statement. She should be like right up in my searches here. Give me 1 second. She made some weird. she made some weird. She said some weird words. All right, hurry up. Why aren't you loading? Here we go. No, it wasn't Buzz. She didn't get the elected chair. She got Miss Beulah. We'll just call it that. Miss Beulah injection. Where is it? She said, all right. I don't know that I can scoot that over and make it bigger. She said, I'd just like to say I'm sailing with the Rock and I'll be back like Independence Day with Jesus, June 6th. Like the movie, big mothership and all, I'll be back. I don't know what June 6th she meant. Maybe it's this one coming up. I don't know. But that's our final statement. Kind of weird. So the woman that was speaking on her behalf up there that adopted her, she, in her appeal, or in that, it's not her appeal, in her, sounds like it was in Whippets. She was in Whippets. I didn't see what her last meal was. I don't know. I'm already off of there. I'll look it up in just a second. I just want to tell you about this woman. Okay. So it says, one, she was never given a retrial. So no surprise there. I'm just trying to scroll on the wrong page. But it says, after the trial, Wuornos was legally adopted by her new friend. I guess she was adopted. Arlene Praley. whatever, like praline. After Praline had a dream in which she was told to, quote unquote, take care of Wuornos. According to Praline, Jesus told her to write to Wuornos, and she did. What Wuornos did not know was that Praline was receiving money for giving interviews, including one with Nick Broomfield, who paid her $10,000. Part of the money went to Wuornos' new lawyer, Stephen Glazer, who Praline hired. Chief Assistant Public Defender Tricia Jenkins, whose office handled Wuornos' Volusia County trial, that's the crimpy hair, accused Glazer of mishandling Wuornos' subsequent cases and appeals. Jenkins testified that Glazer never picked up the discovery files. I don't know why people in my family never know when I'm streaming. Carmen. But anyway, so Praline was her friend and getting money. So she's a little scammer. I don't feel sorry for her. She knew what she was doing. So, yeah. She declined her last meal and opted for a cup of coffee. Anything under $20. They won't even buy you McDonald's today. Huh. All right. I'm going to try something. And then I'm going to text my daughter and ask her what she wants. Did I get taken down? Says I'm up. Says I'm there. So I'm going to, I have, you for reals didn't know that she got that? She did not get the elected chair, though. She got Beulah. She got Beulah injections. Injection. Just one. All right. I'm going to try. I have it set. I have my Valo stuff up. I have my stream ready. Start at 2:40. And I have it set to redirect to me. Because it's all about me. She actually, Zach, she got 6. 6, she got 1, 2, 3, 4, 5. Yeah. She got 6 unaliving penalties. She didn't, even though she confessed to Peter Sims, they never found his body, so she did not get convicted of that. She pled no contest or guilty to the other ones and was sentenced. Let's see. This one we just watched was 12-0. 12-0. It's not score. 12-0. The next one, jury recommended it 10-2. The next one, she penalty trial waived. She was sentenced by the judge. The next one, it was recommended 10-2, 10-2, and 7-5. I didn't know what else to call it because the elected chair is amazing. All right, so I'm gonna end this stream. It should take you to my other stream. I have it set up, but I've got to get there. Yeah, he's against it, and I'm kind of I'm kind of swayed to his side a little bit here, more and more. I don't know, maybe it's because I'm getting older. You heard it here first. Because I used to not be. Like, there are some people out there, some trials we've covered, that it's too bad they didn't have the charges on them. And Jose Ruiz is the one that comes to mind. And I can't even think of the other one that took place in Texas, but they couldn't prove who did it. And so they got life. It's fine. But what they put those little kids through was horrible. And I hope that they have a horrible life. I really do. Sorry. They did horrible things to those children. So it sucks to be them. All right. Let's see what happens. I'll see you in a minute. I think. 5 minutes. I don't know. Don't leave me hanging. I don't know what's going to happen. I'm scared. All right. I'll see. We're going to go see what Miss Vallow's doing now. Okay. All right. Goodbye.